right, thank you for staying with Daybreak. Let's start that conversation that we're talking about on the East African Court of Justice and find out what exactly the jurisdiction is and how they intend to work this out going forward. Let me introduce my guest one more time, beginning from my right, Honorable Justice Nestor Kayobera, President, East African Court of Justice. Thank you so much for making time. And His Worship Yufnali Sokubo, Registrar of the East African Court of Justice as well. Thank you so much for making time. President, I know you've been in Nairobi and holding meetings, several of them. What is the purpose of these meetings that you've been holding?
Yeah, thank you very much, but also thank you for welcoming us in the Citizen TV. So, in fact, the court has been in Nairobi from 12 this month from a number of trainings. It means that all judges of the East African Court of Justice, the two divisions, because you know the East African Court of Justice, it has two divisions. Yeah. The first instance divisions, composed of the 6 partner states, the judge coming from the 6 partner states of the East African community, yeah. And the upper division composed of the 5 judges coming from 5 partner states, because South Sudan is not in. Yeah. Because the treaty provides that in order the partner state that the treaty comprises that the East African Court of Justice upper division, yeah. It is comprised of 5 judges. Yeah. So the South Sudan cannot come in until the treaty is amended to provide for another 6 or 7 judge from another partner state. Yeah. So we've been here from 12 and taking a number of trainings. We start with the training on good governance and the rule of law, training on diversity, cooperation diversity in the community, but also in the Court of Justice. The issue on constitutionalism, yeah. In the East African partner states, and now today we are having we also have a plenary, the court plenary, because the court normally has a plenary, and today we have a validation of our strategic plan, yeah. Of the court for 2018 to 2023. But also, as we were here, we also got the opportunity to make a courtesy call, yeah. To Our Lady, the new Chief Justice of Kenya, to also talk about the forum of Chief Justice. And you know, the Chief Justice of Kenya being the chair of the summit, the chair also of the forum of Chief Justice, yeah. Is the Chief Justice of Kenya. Yeah. We also had the opportunity to make a courtesy call to Honorable Adan Mohammed, the chair of the Council of the East African Community, yeah. To talk about the court and how the court can perform well. So we thought it would be better to come and talk about the court, yeah. As we are in Kenya for 10 days in Nairobi, yeah. Enough so that it is better people of Kenya, yeah. And also East Africans know the mandate of the court and also what we have been doing here in Kenya, okay. In Nairobi.
All right, President, we'll come to the strategic plan 2018-2023 in just a bit, and I'd like to know what it contains really. But before that, Registrar, you know, this court, East African Court of Justice, is not very common among the normal residents. They don't know how far your jurisdiction goes. Please, can you kindly expound on this? How far does your jurisdiction go? What does it entail?
Thank you, Trevor. That is true. In fact, not just even just the common Mwananchi. You may be surprised that even lawyers themselves don't know about the jurisdiction of the courts. Yeah. Either out of no interest to practice regionally, or they are content with all they are doing. Now, the jurisdiction generally is interpreted to interpret the treaty. Now, you cannot integrate without a treaty. It's like the Constitution. Yeah. You remember what we had in Kenya here, like the CIC, the Constitution Implementation Committee. What they were doing is to interpret the treaty. So this court interprets the treaty. And if you look at the provisions of the treaty, particularly Article 6 and Article 7.2, they are so wide to an extent that you interpret almost everything that is happening in our partner states. Yeah. Now, when you tell people to integrate, come together, you must also create a mechanism that will solve issues as they are coming together. Definitely, if you bring many people together, yeah. To integrate, to cooperate, do whatever, there are bound to be disputes. Yeah. So this court then came in, was created, that will be looking at how to sort out those type of disputes. Yeah. So the jurisdiction generally is to interpret the treaty, because partner states in coming together, They're supposed to align themselves with certain provisions of the treaty. Where there's a dispute, then they are free to come to court, and the court will interpret and give a way forward so that they, the partner states, don't quarrel or don't have a dispute about whatever they are doing in their cooperation.
So how many cases have you handled so far?
Ever since inception, there are almost 400 cases which have been dealt with.
Okay.
We have over 100 cases pending, coming from different countries. And to file a case, you file from anywhere within East Africa. In fact, you don't need to come to Arusha. What we have also done is to make it easy for the people of East Africa to file the cases, that we have created sub-registries. It's like an extension of the registry in Arusha in every capital. For example, in Kenya, we have a sub-registry just at Milimani Commercial Court. You walk there and you ask where is East African Court of Justice, somebody will show you. And once you go there and you file, it is as good as you are in Arusha. So that sub-registry is in every capital of the 5 partner states. We are yet to complete the formalities of setting up one in South Sudan. To make access easy to the people so that they don't say traveling to Arusha is far. Even filing fees, we don't charge. It is free so that people come. But of course, as you said, maybe this information is not out there. Sensitization has been a problem to tell people about the courts. Of course, caused by very many other factors, financial and what, to tell people, to drum ourselves that this is what to do, and you're welcome to do this in case you have this sort of a problem. But even the threshold of the cases that come to you, how do they then decide that this one now should go to the East African Court of Justice, and this one we can do on our own? No, it's once a lawyer looks at a case, for example, and feels this is a violation of the treaty, he can come there. Yes. So that's why I was saying, if lawyers first can understand this, the Mwananchi goes to the lawyer if he has a problem. So the lawyer needs to understand it, then you tell him, now this is a good case to go to the East African Court of Justice. If he looks at it and looks at the treaty and says, this is a violation of the treaty, we need to go there, then they will come. All right. President, you've been there for just about 4 months, but you've been in the leadership for more than 7 years and beyond. What would you say is your greatest success, and what is your plan going forward to even just popularize the court, like the registrar is saying, that people simply just don't know how, at what point they should come to you?
You know, as you were saying, rightly saying, I was appointed on 27th February this year by the Summit of Heads of State. And since my appointment on that date, we decided to work together as a team. Because when I joined the community, the court, I decided to be guided by 3 mottos. One being the teamwork. By teamwork, we decided to work together with the other heads of organs, the Secretary General and the Speaker of EALA. Because we thought, as a team, as the 3 heads of organs, if we are together, we can go further. Because the objective is the same, the vision is the same, and the mission is the same. And then we decided to go together to see the wisdom from the heads of state. So we started in Rwanda, where we met His Excellency Paul Kagame. From there, we went to Uganda, and we met His Excellency Museveni, President Museveni. From there, we went in South Sudan, where we met His Excellency Salva Kiir. And then from there, we went to Bujumbura, where we met His Excellency Evariste Ndayishimiye. From there, we went in URT, when we met Her Excellency Samia Suluhu Hassan. And then from there, we went in Zanzibar, and where we meet also His Excellency Dr. Mwinyi. Then we are thinking to come also to see the chair of the summit, His Excellency the president of here. So we feel by working together we can go further. And then from there, we decided to revive the forum of Chief Justice of Forum. Then we made that meeting in Kigali, Rwanda, in May, where all the Chief Justices of the partner states met in order to see how we can revive the forum. And then now we had to come here and see the Chief Justice of Kenya, Honorable the Lady Justice Martha Koome. And then we met with her and we discussed about how we can revive that forum of Chief Justice, because she is also the chair of that forum. So from there also we have made two sessions. So in May, we made the session of appellate division, and then we were able to do about 19 cases from appellate division. And also in June the first instance division also made the court sessions also in Arusha, where they also to make a number of cases. Of course, in August also we have the court sessions appellate, and then in September we have the first instance division court session. So from the fourth month I have been there, I think now the court is reviving. But the main issue now we are looking forward is how people can know the court. It's what the research is saying. Now we have met the chair of the council. We share with him our program that at least how can we do our court session in partner states so that the court can be known by the citizen. In November, the court will be celebrating its 20th anniversary in existence. But in 20 years of existence, still the people of East Africa don't know the court, the business of the court, the jurisdiction of the court, the powers of the court. But if you see the jurisdiction of the court, you can see that the court has made a number of important cases, starting from the Anyang Nyong case, the Ziwa case, the Ayala case, all those cases, the EAB, the BAT case. So you can see that the court has been able to make a number of important cases, but still we think if the court is known by the people, the court can be also be well doing, because the power of the court, the Article 23 of the treaty provides that the court is the judicial organ of the community. So whenever there is a dispute between the community and the citizen, between the partner states themselves, so the people can access the court, which is the judicial organ of the community. It must be known by the people, by the attorneys, by the private lawyers, by the government lawyers. It's what we are doing.
President, one of the things you mentioned in terms of the training was constitutionalism. And this is where the rubber meets the road, so to speak. What do you think are the biggest challenges when it comes to interpretation of what is constitutional and what is not constitutional? Because even right now in Kenya, we are locked in a situation where there's a judgment that is expected on whether something was constitutional or not. What do you think is the biggest challenge when it comes to interpretation of constitutionalism?
You know, first of all, is that the constitution of the treaty established the East African community. That is it is an international agreement between the partner states. What right to say the constitution of the community is the treaty establishing the East African community. So whenever there is a violation of the treaty, now the East African Court of Justice comes in. But also whenever there is a violation of the partner states' own constitution, whenever there is a violation of the partner states' own laws, now the community, the East African community, East African Court of Justice can come in. So when we are saying about constitutionalism, that is the fundamental law of the community, which is the treaty, and the other enabling laws. So when we are saying about the constitutionalism of the community, it is about respecting the mother law of the community, which is the treaty establishing the East African community. But also, whenever there is a violation of any partner state's internal law, it means also there is a violation of the treaty. So when I say about constitutionalism, it is about respecting the mother law of the community, which is the treaty, but also the constitution of the partner states. They must also be respected. It's, for example, why even from the partner states themselves, you can see that there are cases which have come from the partner states about their own laws. We have, for example, what we call the journalist case from the Republic of Burundi. It was the law which was passed by the Constitution of the Republic of Burundi, but which was also challenged in the East African Court of Justice. And the court delivered is ruling, and the Republic of Burundi was to abide to that law, to that judgment.
Okay. Registrar, you know, the President has mentioned that the court is turning 20 years, and it has been there in November. What are some of the key achievements from where you stand? 20 years is a long time.
Yes, indeed 20 years is a long time. One of the achievements I can mention is that in its decisions, the court has clearly defined some of the principles of integration that partner states now have to follow. For example, that were not clear. Second thing, I'll say that for a long time, this court was issuing what is called declaratory orders. Now, a declaratory order, you take it and you go away with it. It's like a declaratory order says what Trevor and Mbija have done is wrong, full stop. So you'll say, fine, you have said what I've done is wrong, next time I'll not do it.
Or I'll say, I'm sorry.
Yes. Now it has gone further. What Mbija have done is wrong, and you're going to pay these damages. It did that in 2 cases, and now they're being followed. So that is also a way of encouraging people. You don't just go to East African Court of Justice and walk away with a paper called a declaratory order. If indeed the defaulting party was found to have made a mistake, it can be declared to pay damages. 3, and most important, the court has clarified the rules on elections of EALA members by national parliaments to EALA. This has been a problem almost every election cycle of members of parliament to the EALA, starting with the famous case of Anyang' Nyong'o. If you remember it, how it was protracted. It continued, went to Ugandan cases. It continued, went to South Sudan. The last election of EALA members, Kenya were the last ones, despite the court have been clarified. But it took time, but eventually at the end of the day, they followed. Another achievement which I can say is the court has clarified on the Customs Management Act that partner states have to follow. The case of BAT, the law president has mentioned, it was about goods coming from Kenya going into Uganda, goods made from Kenya. And then Uganda says, these are foreign goods, so the tax on them should be high, and the goods were going to BAT. BAT said, no, these goods are from Kenya. Whatever you charge Uganda manufacturers of that type of goods is the same you should charge Kenya manufacturers. So they came to court, and the court told Uganda, no, that is wrong. So you must go back and change your law to be in line with the East African Customs Management Act, because these goods are from Kenya. You treat them the same way you treat similar goods manufactured in Uganda. Another achievement was in terms of actually journalism. Tanzania, as you know, passed some laws, Media Act, that was had a lot of provisions that made it difficult for journalists to operate, and they came to court. At the end of the day, the court said the provisions of those acts are against the treaty, and ordered Tanzania to go back to a parliament and amend those laws to be in line with the treaty provisions, especially on the rule of law, good governance, human rights. And now Tanzania is in the process of doing that. Those are achievements we cannot forget. Another thing is that the opening of sub-registries to make it easier, to take the court to the people all along. You can imagine somebody coming from the far end of South Sudan and wants to come to court. It becomes very difficult. So that made access to the court easier. We have also deployed IT. During the pandemic, we were among the first institutions to work as if there's no pandemic. When it came, of course, all of us panicked. People moved all over. Most people ran back to their homes, their capitals. But we started operating as if we are not in a pandemic because of the system we have put in place. So cases were going on. We connect the lawyers. We connect the judges from wherever it is. We connect the staff from wherever we were. We have a system called case management system that has everything in that system. In fact, you burn down a building, tomorrow we have everything. So we have continued to progress by employing information technology. And I think going forward, that is a big, big plus for us, I can say.
So those are the achievements, but there's always the flip side. What are some of the biggest challenges you think you're facing? Because you mentioned you have about 100 cases that are still pending.
Yes. Now, one of the challenges is that the judges are not permanently residing in Arusha. We have only the president and the principal judge residing in Arusha. The rest come as at when we need them. Although we have a calendar, they'll come this month, the next month they won't come, they'll come that month. So you see, that creates that gap. A case which will have completed in 2 weeks then takes longer period, because just when they started, the session got finished, the judges had to go away. Then you have to wait again. In the process, other matters are being filed under certificate of urgency. What do you do if the session just ended last week, the judges left, and today somebody is coming with a matter of life and death, certificate of urgency? What do we do? It's causing a problem. So we have been appealing to our Council of Ministers to consider making these judges, their residents, to be permanent in Arusha for the entire period of their appointment. The judges serve for 7 years. So we are saying for these 7 years, they should be there. Then when they finish their time, they go. Another team is appointed. That's a major challenge. Another bigger challenge is that the people initially intended to use the courts are hardly coming there. Just as I said earlier, when you are bringing up people together, you must look in the event of a dispute. So this court was initially looked at to be a trade dispute resolution court. Remember, the government will provide the environment. Who are the people who do the integration? The business people. Those are the ones who move around. We hardly see them coming. Yet you hear their problems. They tell you their goods could not get to certain destination because of a problem. There was a problem at the border. They don't answer. Instead, they go to the ministers. The ministers have to meet. Ministers should be making policies. And they made a policy that in the event of that problem, the court should solve the problem. But they don't come. We really don't know why. I wish one of them was here to explain why they don't come to court.
Yeah.
They don't. We don't know whether it's because of sensitization or not, but many a times when we get an opportunity to talk to them, we have been telling them, this is a court which was set up by governments, first of all, your own government, so you should not fear coming to it. Yeah. Otherwise, why did they set it up? They set it up knowing you need to use it to solve some of those integration issues. That is a major challenge. Okay. Of course, another one which cuts across is finances. The budget is always never enough. Yeah. We would like to do more than we are doing. We would like to sit throughout the whole year. The judges to sit there throughout the whole year. We cannot afford that. Yeah. It is also, we are also addressing it. We are trying to explain to our partner states the benefits they will get by increasing our budget. We will do more cases. Yeah. And there are also parties to these cases anyway. Most of the people sued are governments. Actually, 99.9% are governments. So it is in their interest also to make sure the court operates properly. Yeah. It's like a seesaw, it cuts across. Okay. Goes the other side, it cuts somewhere, comes this side, cuts the government. Yeah. Yeah. So it is also in their interest to make sure the court is well operating because they are also beneficiaries. All right.
President, what are the highlights of this strategic plan you spoke about, the 2018 to 2023? I'm sure most of those things are captured there, how to counter them, right? For you, what are the highlights of this strategic plan you spoke about earlier?
Yeah, in fact, as the Registrar rightly said, we are looking forward how we can mitigate these challenges. For example, the not known court. We are looking forward how the court can sit in the partner states. So the modality of the court making the court sessions in the partner states in order the court be known, but also be well known. That's one of the things we are looking forward in the strategic plan. But also, we have already, for example, there is a bill, an administration of the East African Court of Justice bill. Yeah. So we are looking forward how the court can be an independent court. Because the court should not only be working under the East African Secretariat. So we are looking how the court can be more independent in order to deliver justice. Yeah. But also we are looking how the community also can be benefiting from the court. As the registrar said, this is an international court, which is guided by the international treaty. Yeah. So for us, we think the court is established by the partner states. So the court also can be well doing its business if it is facilitated by the governments themselves. Yeah. So all those are the issues, how the court can perform well, effectively, properly, efficiently. That's the main agenda of the strategic plan.
Yeah. But as you take on the president's seat, how are you going to ensure implementation of the rulings of the court? Because that has always been the biggest challenge everywhere, world over.
Yes, the implementation of the court's judgments. Yeah. From any international court, it comes from the goodwill of the government. That's how it is. Yeah. But from the past, we have seen that the governments themselves, they have been implementing the judgments of the court. Yeah. Because now not implementing the judgment of the court, it becomes also contempt to the judgment of the court, which is also another violation of the treaty. So the government have been implementing the judgment of the court, yeah. Even though implementing the judgment of the court it is from the goodwill of the government. So how a government cannot be implementing the judgment of the court itself, it is a creature by the government themselves. Yeah. So you can see all of those important cases. Yeah. If you see the Sitenda Sebaro case, the government of Uganda, but also the East African Secretariat, they implement the judgment. If you see the Plaxeda Rugumba case, the government of Rwanda, it implemented the judgment of the court. Yeah. Also the Ayala cases, which the registrars they are alluding to, the Republic of South Sudan, but also the Republic of Kenya, implemented the judgment. Yeah. So what we do, it is only that the court be known, the powers of the court be known, the duty of the court be known, but also be known by the government themselves. Because we can see that even the government attorneys, they even themselves don't know the court. So on the matter of implementation of the judgment of the court, we don't fear. Okay. The government themselves, they are implementing the judgment of the court because it is their court.
Okay. As we wind up on this, what is that one thing you want to be known for at the end of your tenure as a president?
It is that the court be known by every citizen of the partner states. Okay. So if the court is not known, really, that will be my failure. Okay. So it is why for example, we have been meeting with the chair of the council. I think that the chair of the council can tell his colleagues, some of the members of the council, to let the court perform well by increasing the budget of the court, by increasing the budget of the court, also for the training of judges, the training of the attorneys people, so that the court be known. Because if the court is known, it is for the benefit of the East Africans, but also it's for the benefit of the governments of the member states. Okay.
I said, taking closing remarks with you, Registrar, what is the one thing you wish the people who are listening today will hear from you as we wind up on this conversation?
I would like to see a situation where people access our court paperless. Our vision is to be a world-class court dispensing quality justice. Now, it cannot be a world-class court dispensing quality justice and then we're still using a lot of papers and carrying files the way it used to be ever since the judiciary started. So my focus or a lot of energy will also be put to IT system, which we have done quite a bit, to ensure the court is paperless. You can be in court from whatever point of the world. You don't need to carry a paper. Everything is paperless. That's what I would like to see.
Okay. Yes. What about ADR? Are there any other alternative dispute resolutions?
Yes. The treaty provides for arbitration. And the treaty also provides in the scheduling conference you can go for mediation. And we train our judges on arbitration. You don't just sit as an arbitrator because you are a judge. No, because arbitration is a completely different ballgame of training. We train them. And we have encouraged our partner states, and I can tell you some partner states have taken it up, that all their government contracts, they have changed that provision on dispute resolution, where they're saying if we have a dispute, we'll go for arbitration at the East African Court of Justice. We have about quite a number of arbitration matters that have been referred. Now, those ones don't have to necessarily involve the governments only. Even private, commercial agreements, you and your friends, other businesses, they are free to appoint East African Court of Justice as the court that will do arbitration. For those who have filed cases there, just before the case goes now for hearing, what we do scheduling conference, they can decide to say no, before we come for hearing, can we do mediation? And then the mediators will be the judges. 1 or 2 judges can be appointed to do the mediation. Just before I forget, next week we will be doing a mediation here in Nairobi, involving, it is not even involving Kenya, imagine. South Sudan and another organization completely. But the mediation is being done by East Africa Court of Justice and is being done in this country. So we have also opened up to ADR. So it's not just strictly the court process, we have a window for ADR.
All right. President, final remarks from you.
Yeah, thank you. I think now that we have I am in office for 4 months. We have making some training for judges in the staff of the court. Now we are looking forward to have the court session in August for the Upper Division, and in September for the Business Division, and also we are celebrating the 20th anniversary of the court in November, and we are looking forward to have a court session in November in one of the partner states. So the purpose being that at least in 20 years of existence, the court must be known by the citizen, by the government lawyers, also by the private lawyers. So what I can say is that the court be known by the people, by East Africans, but also by the governments of the members of the East African community.
All right.
Yes.
Thank you so much for making time this morning, Honorable Justice Nestor Kayobera. I wish you all the best, the President of East African Court of Justice, and His Worship Euphnalis Okubo, Registrar of the East African Court of Justice. If you didn't know about them, now you know, and everything that they do. All right.